Inside the courtroom, this hearing wasn't about guilt or innocence, it was about freedom, and whether that freedom should come with limits. The defendant asked for permission to work while on bond. But with serious charges and strict monitoring already in place, the judge had one responsibility above all else: protecting the community. The judge asks who the defense attorney is. She asks about the status of the case and discovery. The lawyer explains that today's hearing is only about bond modification. The main case is scheduled for the 19th. The judge then confirms that the defendant is asking permission to work.
And the court was just wanting proof of employment, and defense counsel did provide that.
This was directly from the pretrial service officer as well.
Okay. All right. Let me just explain. I'm a little bit confused by the document, or maybe I'm interpreted incorrectly. All right. State, do you agree that the hours he works are from 9 a.m. to 8 p.m. Monday through Saturday?
I mean, I don't agree, Your Honor, because I don't know. My understanding was that was his personal business.
Is this your personal business? And what do you do?
Think of Geek Squad.
I'm sorry, what?
Think Geek Squad. I'm a computer guy. I repair computers. So I have a PO box where I go pick up computers and I go to people's houses and I knock out computers, whether it's businesses or computers, and not to mention that I work for another company that does ATMs. So I do Rocket Criminal, which is Bitcoin ATMs. So
I'm sorry, you need to speak up.
I also fix ATMs. So you think like I'm not sure if you know about Bitcoin, but Bitcoin ATMs, that's what that is as well. So I have a contract with a company that does Bitcoin ATMs where I have to move. That's the reason why I'm asking.
All right. So what I can tell you is, one, I didn't know this was your own business. This 9 a.m. to 8 p.m. doesn't work for the court. I'll allow you. Well, I mean, this is what I'm telling you. I'm not doing 9 a.m. to 8 p.m. and 10 a.m. to 8 p.m. I'm not doing it because the hours that you're posting, these are hours that you say. I don't have any proof that this is actually occurring. All I have is your word saying I'm going to a PO box to pick up computers, and I do this from 9 a.m. to 8 p.m.
And I also look at houses.
Well, again, this is from 9 a.m. to 8 p.m. I don't have any proof of that. All I have is you're saying it. And I'm not going to agree to a time from 9 a.m. to 8 p.m. That's more than 8 hours a day.
Your Honor, an alternative, my client would be able to limit his hours to a traditional 9 to 6, 9 to 9, or I guess it would be 8 to 6, just to give him that window of being able to travel.
I'm not doing it. I'm telling you, if I allow him to do this, it's going to.
The judge says work hours must be normal business hours, from 9 a.m. to 5 p.m. Even during those hours, the defendant must provide proof of where he goes. If he visits a P.O. box, he must document the time and location. The judge explains past problems with GPS monitoring. She says she understands the request, but will not allow flexible or long hours.
Your hours to 9 to 8 p.m. The state is saying they don't want you to have it at all. I understand why the state is saying no, because you're on bond for continuous violence against family, violation of bond or protective order, assault and stalking. So here's the thing, whether it's true or not, I don't know. All I know is what your charges are. All I know is my job is to protect the community. All I know, at least one of them, all I know is your attorney is saying that you can't pay for this GPS because you're on full house arrest. So this is what I'm sorry?
I can't pay for anything right now. I'm about to be homeless.
Yeah.
This is why I need to work.
All right. I will tell you this.
I need to work Sundays too. And I need to, and if I'm
Well, that's not going to happen.
Your Honor, if we can ask that it be modified to the 9 to 5, my client will provide the necessary proof at this point. If that is the court's order, he will abide by the court's order. And I will make sure that he understands that that is the court's order at this. It is better than nothing at this point because he does need to get to work, Your Honor. He is going to be homeless soon if he cannot start making, money. He's made current arrangements with his landlord to allow him to stay there. But he is behind, I believe, a month or 2 months behind rent already.
I need to leave. He's already given me a termination of my lease. So I need to get out of there.
Mm-hmm.
So I gotta be able to generate something. And maybe I was I was asking for just tracking only so that I could move around.
No,
and do what I
tracking
need to
is
do.
not going to be allowed. That's not even a consideration.
Can I speak? I don't know.
You can
No,
speak,
no,
but I'm telling you.
No. I'm just gonna ask a question.
Sure.
I'm asking a question. So I was told the other day by the DA that I'm gonna listen to you. You know, I'm not gonna talk.
No, I'm listening. Go ahead.
I'm not gonna talk.
No. Here's the thing. I will tell you, I keep an open mind. The issue that I have with you is that the timeframes he's asking for, there's too much of an open window. And basically, if I allow him to do this, it is sort of like tracking because he's saying he's working from 9 a.m. to 8 p.m.
Yes, sir.
I don't know if he's going to a PO box or whatever. Somebody would have to ask the
I'm not gonna roll.
The defense agrees to follow the court's limits. They say the defendant will adjust his business to fit 9 to 5 hours. They ask the court to approve this so he can earn income. The judge says she will set strict rules and wants the order written clearly.
all to write this up and state, I know you're not in agreement with it, but I'm going to want this written up. So his hours that he's allowed to work are from 9 to 5. That includes going and coming. He is going to have to pick a specific time when he is going to be traveling to go to his PO box. And he needs to put down the location of the PO box. And in these hours from 9 to 5, Monday through Saturday, he needs to put in the order the time and that block of time that he's going to be traveling to his PO box. And if somebody calls him and they want a computer repaired, he needs to call pretrial services to let them know, I've received a phone call. This is the specific address that I'm going to either pick up a computer or repair a computer at this address. And he needs to tell them how long he's going to be at that address. Yes.
How about when pretrial don't answer because they never answer? I can't even speak to my pretrial officer. He
Send an
doesn't-
email.
Your
I
Honor,
have proof of all the emails I've sent to him.
Well,
Your
yes.
Honor, if I may,
Mhm.
if I may, I understand the court's order. I know he needs to give documentation. I know he needs to tell them that he's going to go. But sometimes, as he is saying, there is time constraints of when.
I'll just put it in an email. It's
And-
a paper trail.
Of course, Your Honor. So he wouldn't need confirmation from them to say, yeah, you can go there. It would just need to provide documentation of proof. This
No.
is where I'm going.
This is what the court's order is. He needs to sit down with you. And for each Monday through Saturday, his time he's allowed out is from 9 to 5, and it has to be work related only.
Of course.
So for example, on Monday, if he says, I'm going to go to my PO box at 10 a.m. and he needs to pick that date, not I'm going at 10 a.m., then I'm going at noon. No, just pick one block of time that he's going to his PO box. In the order, put, defendant is allowed to go to his PO box on Mondays at, if it hypothetically, it's 9 a.m.
Mhm.
At 9 a.m., the PO box is located at this physical address. He's only allowed to be there for no more than an hour to get whatever he needs from that PO box. Now, mind you, sometimes people are standing in line.
The judge explains how GPS tracking will work. The defendant is allowed to go to his P.O. box only once per day. The GPS must show that he is actually at that location. If he goes to repair a computer, he must report the customer's address, must also notify authorities when he leaves the location.
Email or call GPS and said, I'm going to go repair this person's computer. This is the address.
Okay.
And when he goes to that address, when he gets ready to leave from that address, because the GPS should show I'm at 300 De La Rosa and I'm still here repairing a computer. When he gets ready to leave from repairing that computer, he needs to send them an email and said, I've completed repairing this computer, or I'm leaving this location, and then he goes back to his home.
Okay.
So if y'all can
Can I stop and get something to eat?
no,
I can't
Just
stop and
for
get
work.
something to eat.
that's what Uber, don't they have Uber Eats or something else that happens? They
And who
have
can
delivery.
afford that when I can't work?
All right. Let me just tell you, here's the problem. And I want you to internalize what I'm saying.
I am.
No. I mean, seriously, internalize it. I do not take any of these charges against anybody as true. I don't take it as beyond a reasonable doubt because I haven't seen any evidence. But my job in this part of the process is to make sure that the community is protected. Part of your problem is you're charged with continuous violence against a family member. You're charged with violation of a bond or protective order. And when you have a violation of bond or protective order and it's in felony court, that means that there are extenuating circumstances against that. That means that somebody allegedly has told you before, this is a protected class of people, you're not to be around them, and allegedly you violated. Then I have assault stalking.
They violated. I didn't violate
Here, then we have this assault stalking thing. So
Yes, sir.
that person will be very concerned. And so, do I consider the complainant? Yes, because at the end of the day, the complainant, whether what they're saying is true or not true,
Sure.
they don't want to end up at some store and then all of a sudden they see you.
If I can give some context, just
Yes.
on my client's behalf, because I know he's wanted me to say it at this point,
Sure.
is that the complainant has submitted two different, I believe, affidavits or statements to the DA's office where she has recanted her story, as well as the mob modification has been modified to no harmful and injurious contact.
Mhm.
So I believe my client, I think what he's trying to get at is
The defense argues that allowing work will not harm the community. They say the complainant supports him working. The judge responds that safety is still the court's responsibility.
All right, so this is what we can do. We can set this for trial next week if you all want a trial. I'm here. You're here. The state's here. I can put it on
I
trial.
believe we're close to an agreement. We've been conferring on the matter
All
already.
right, well, I mean, if you all want, I'll call you back May 13th for a jury trial. You can either do a jury trial, bench trial.
I'm not
Let me
scared of
explain.
none of that. Nothing happened.
No, what I am telling you is, and this is the problem, I don't know why you won't listen. That's part of your problem. You don't listen. Now,
Don't even
what
know.
I'm telling you is, I will bring this back on May 13th. You can either have a bench trial or a jury trial. Will you be ready for jury trial on the 13th?
Your Honor, there is another.
There's another case, Your Honor. We are trying to, we're close to wrapping all of his cases up in a global offer. We would just ask that the court give us some time.
On May 19th, Your Honor, when we're coming back, on that day, we will have the answer whether
Right,
this
but-
is going to be a plea or a trial.
But what's the other trial?
Thursday, right, Your Honor.
All right, so then I have that to work with. So this is what we're going to do. We're bringing back this on May 13th. That'll be your jury trial date. The witness can come, not come, whatever is going to happen. May 13th, jury trial.
Thank you, Your Honor.
All right, thanks. Ms. Ferguson, give them a date for jury trial, May 13th. Oh, it's going to be a jury trial.
In the end, the court didn't deny work, but it didn't trust blindly either. Every hour, every location, and every movement came with rules. Because in cases like this, being out on bond isn't freedom, it's responsibility under surveillance.